going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great night. I am so sorry I'm late. I don't know how long I'll be live for. It may only last 5 minutes, but just wanted to jump on real quick and at least start the clip. But yeah, got some massive storms in my area right now. Kind of scary, to be honest. But yeah, power came back on, so let's do it. Let's have some fun. Um, yeah, this is part 3 of the Judge Simpson case we've all been watching. All right, I'm not gonna blab, so let's just get into it so we can, hopefully get some content in. All right, let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Oh yeah. Thank you so much, Jedi, for holding down the fort. I really much appreciate it. Jedi and all the other mods. Again, I don't know how long I'm gonna be live for, but yeah, my power was out. It is back now. So let's go.
And we're ready for it. Court does call the case of the people versus Fareed Shah.
Joseph Blanchard on behalf of people.
Good afternoon, Your Honor. The court, please, Mark Krieger on behalf of Mr. Hajar.
And Ryan Moran, P. 3665 on behalf of Mr. Hajar, who stands present for the record. Hajar, please state your full name for the record. Bring it to the record.
All right. Feels like Groundhog Day, but we're here for the PCC as well as, I believe, consideration of some other type of release or alike.
Right.
So go ahead. Well, let me first say this. I received all of the information that you sent me. I believe, Ms. Blanche, you received it.
Yes.
I don't know if you've had an opportunity to even go through it or.
I mean, I went through it. I wasn't able to verify anything, so it was just sent.
Got it. You're right. I mean, it was yesterday, and I want to thank counsel for interrupting my viewing of Olympic coverage while I tried to go through it as best I can. But I mean, I'll let you go ahead, but
You're exactly right, Thing. And some people started watching it not knowing what it was, and now they keep on watching. How does that end? Oh man, how did I forget the lamb chop song?
it's going to be a bit difficult for me to rule on that, where the people, I don't think, have had an adequate opportunity to go through or try to verify everything.
Well, I can state as an officer of the court, Your Honor, that we received the 1040s and the 1120s from the accountant.
Yes, thank you everyone for sticking around. I appreciate all of you. You guys are awesome. I don't know if I said that in my intro, but yeah, you guys are awesome. Thank you so much for hanging out.
And he verified that these were the tax returns that were filed. I don't know. You can see we got the mortgage statements directly from the mortgage companies, but if I'm
not disputing that anything that you've given is real.
Okay.
I'm not doing that. The people may want to look at something else and in terms of what's there. So there's that issue, but I'm not challenging any of that. The only thing is that when you receive this, it's attempting to try to analyze everything that I'm looking at that can be a bit problematic to kind of do in a day and a whatever.
In an effort to be, because when, I don't know if the court will recall, I asked to approach the bench, what kind of financial records.
Right.
And the court had raised an issue about his separate business.
Yes.
In an effort to be completely transparent, well, what I would be anyway, I attached the 1120s for the business.
Yes.
But those are just pass-throughs. Everything's got to be shown on the 1040s. But I didn't want the court to think I was omitting anything, but the 1120s just are a pass-through to the 1040s. So the 1040s are the.
No, I got that because it's an S corporate. So I
Right.
understood it.
Okay,
I got that.
I just wanted to make sure, but I didn't want to admit those and I wanted the court to have the benefit of it. Your Honor, we were here last, the court had indicated that if he was not able to post a bond, that you would consider, although certainly didn't promise, you would consider the 10% of the $2 million. We have gone through 2 bonding agencies and we have not been able to satisfy the bonding agencies. And we have not been able to get a bond. One was a bonding agency, I think local, and another one was out of state. I forgot whether it was California or California. But in any event, as I stated at the last appearance when we were arguing the bond motion, that there were people that were prepared to post their house, and including Mr. Hajar's house. I actually have an appraisal of Mr. Hajar's house, and if you look at that, plus his friend who is here, Gus, I don't know how to pronounce your last name. Shakira. He has a house on a lake in Bloomfield, which
West Bloomfield. I remember. I saw it.
Okay. And so if you take those 2 together, you have $1.45 million in equity, probably a little more because.
Well, yeah, but let me stop you there.
Okay.
Because while
People are putting up their houses for this guy. I mean, what is the best case scenario that comes out of this? I mean, the defense is gonna have to prove that he had nothing to do with this. When you have cell phone locations pinged, I mean, I know this is all, I don't know, that's what the prosecution's saying, but what is the best case scenario out of this? And in my head, which I know I shouldn't think this, I feel like he's going to be, found guilty of something. He may take a plea deal down the road. I don't know. I don't know if he committed homicide, but what it sounds like is someone passed away in his house. And then his cell phone was pinged at a location where the body was found. I don't know. I had a conversation with Judge Fletcher about this, and I found out that I'm not impartial. I apparently generally believe what the prosecutor's saying, which isn't a good thing. I need to get that out of my head. But people putting up their houses for a guy that might be out of jail until, the trial ends, it might be a year, but I just have this feeling he's going to be doing some time. But I don't understand why people are putting their houses up.
that's the amount of equity, and maybe what you're running into with the bonding companies is that were the parties to go and obtain, say, a line of credit or a mortgage of some type, using that property as security, they're not going to be able to do that to 100% of the value. They're only going to be able to do it to 75, 80%
Right.
of the value of the property. So.
Right. And I think actually that is to our advantage, and I'll explain why. So if you hear me out for a minute. But,
I will.
okay, so there's probably a little more equity in Mr. Hajar's house than I mentioned in the email that I said that explained everything. And the reason is because if you look, the mortgage was taken out in 2020. We couldn't get the current mortgage statement, but that was the mortgage. So that's been paid down for 3 years. It's probably not significant because, as the court knows, principal doesn't go down early on in the mortgage, and it's been 3 years. But it probably is maybe another 10,000 or something. But I don't think it's hugely significant. But the reason I say is that if we were to post the property, they couldn't encumber it any further. The court would certainly be first in line, and we would be prepared.
No, we wouldn't.
You second in line to the current mortgage, but they couldn't refinance it. That's what I'm saying.
Okay.
But you would be second in line to the current mortgage, but even with being in second in line, there's still 1.459 or maybe just a touch over that in equity. So what we would do and I've done before, is we could file a quitclaim deed with the court that would be registered with the Register of Deeds. So they couldn't take out any home equity loans or any lines of credit on those mortgages because it would be quitclaim deed. And then the court would hold it. If he doesn't show up, it's the court's property. If he does show up, later on, he gets it back. And the reason I say that this is, I think, better security if he posts a $200,000 10% bond plus the two properties, he has an incentive because if he posts a $200,000 10% bond, he's going to get back $180,000. If he paid it with a bail bondsman or bail bondswoman, which he can't do, they would keep the whole $200,000 and they would have the equity in the home. So here you've got an incentive because he's going to get back $180,000 on the 10% bond, and the court will have the two properties, one of which is his very close friend. And but the court has never indicated there's a danger to the community. I mean, that there's a risk of flight. But if he violated his bond conditions, he would be putting his friend, which has over $700,000 in equity, in peril that he would lose all that money. So I think what we've proposed, Your Honor, is a 10% bond plus the two residences, which give another 1.45, let's say 1.46 million plus 200.
That judge is awesome, isn't he? He's so good. I just like how he doesn't filter what he wants to say. Like I love it. I love it. And again, I said this in my video earlier, but giant shout out to Team Skeptic for finding that court. It's yeah. I just wish he had more hearings. He'll have a 6-hour docket and only have 3 hearings. So it's sometimes a little boring to go through. Okay, let's go.
100,000. Now you're up to 1.66 million. So you're really close to the 2 million total.
But I don't.
The only difference now is, and it's to the court's advantage to make it a 10% bond rather than a $200,000 cash bond plus the properties. Because it was a $200,000 cash bond plus the properties, he'd get the whole $200,000 back. But if it's a 10% bond, he has to pay a 10% premium to the court for administrative costs. So the court indicated last time that it would consider that 10% bond. I tried to convince the court that we would do more than the 10% bond, and that is by posting the 2 homes, which puts you really basically at just under 2 million.
Well,
a couple 100,000 short.
But a
little more, actually, 300,000 short.
I'd need to see your proposal that you're laying out to me in terms of quitclaim deeds and everything. I'd need to see that in writing. I'm
okay.
Not gonna outright reject it because of the way the courts are structured. That proposal would in some way have to go. I'd have to send that at least, although it would be the court's decision, to corporate counsel to make sure that they.
Because here, let me
those issues. But let me just say this also.
Sure.
I don't agree with the way that you have addressed the numbers. You're addressing raw numbers, but I think you also need to take into account that, and I'm always going to look at it in terms of worst case scenario. So let's say I do that, he takes off, doesn't appear. I now have that money, the 200, but then I have these houses which are encumbered. And I'm and when I say I mean the court would be second in line on any type of foreclosure if it wasn't being paid.
That's correct.
And I know what happens to creditors that are second in line.
Well, but
if it's foreclosed on and then sold.
But there's no question, Judge, that there is considerable equity even over and above the mortgages. I mean,
yeah, but it's not, listen, it's not equity that I can, that the court can do anything with. I mean, I hear you. I hear you in terms of the value, but there's not a whole lot that the court can do with that.
Oh, they could
I
force
mean-
a sale. The court could certainly force a sale. In fact, if I may.
Yes, but then, okay, you're talking about then a procedure that there's a reason why this is very rarely, if ever, done. I think in the 25 years I've been on the bench, there's been only one other case where this I've even considered taking real estate.
Yeah, the court will specifically provides for real estate.
Oh, I know what it provides. I also know it provides for a lot of things that sometimes don't happen.
What I have done this in federal court in forfeiture, and what we've done is we've reached an agreement, and I'm happy to put this all in writing for the court, but that what would happen is that that there would be that the county or the prosecutor's office or whoever would have the right to force a sale of the house within X amount of days of his failure to appear. But the courts never really saw this, at least my understanding. This court is, I've not seen the court be concerned about a failure to appear. What I've understood the court's concern is a danger to the community.
Yes.
And so basically what we've proposed here monetarily, if the court is concerned that the $2 million, which the court said it would let stand, it wasn't going to raise it, but would consider reducing it to a possible 10% bond with a combination of conditions, then you're almost basically in the same spot you would be.
I have part 1 and part 2 linked in the description. They're down there. You should be able to see it. So yeah, I highly encourage you watch part 1 and part 2 before this. But you're going to hear a lot of the same thing. It's the same hearing 3 times pretty much. Once you watch part 1 and part 2, you'll understand that.
If it was through a bail bond, the only difference really would be that in terms of danger, not risk of flight.
Well.
Oh no. Okay, yeah, I forgot I made that private. Something happened in that stream, and I need to go edit it out. I'm gonna have to do that after this stream. You're not you. It part 2 is exactly the same as part 1. If you've seen part 1, part 2 is exactly the same. I will say that.
But the only difference is that the court becomes the surety.
Well, the court's not the surety. The surety is the property.
Oh, no, we do, because then we would be the ones ultimately that should something go awry, that would be executing on the property. So, I mean, in effect, that's what we would be doing.
I just got a note, Your Honor.
So I'm bringing it up.
Yeah, that there is another house that's worth $450,000, which is free and clear, and that we could post. So now you're well over $2 million.
Okay.
Not well over, but you're over 2 million. I shouldn't say well over, but you're over 2 million plus the 200,000. So now you've got basically 2.2 million. And I can prepare the quitclaim deeds. I can do all of that work myself, and present it to the prosecutor in a written order for the court to examine.
All right. I don't have any problem with that. I need the structure of what you're posing in writing, because while certainly the court, me, I can make this decision, I also want to make sure that the court and the county are covered regarding this.
Fair
So
enough.
I can tell you that I need something in writing that I would be able to potentially send to corporate counsel, or review myself, send to corporate counsel regarding this issue to make sure that all of the bases are covered.
He's done that a few times. There is some movement that makes hearts that he does every so often, and I was very confused at first. Like, why were hearts just appeared on the screen? But yeah, whatever software he's using, whenever he makes certain motions, different animations pop up. It's hilarious. I don't know if that still happens. I haven't seen it in a while, but it is hilarious when it does happen.
and then also make a determination, and then make my determination as to whether or not we would go. If you said there's 450,000 on another home,
Correct. Is that?
that's free and clear?
In Livonia, free and clear.
Okay.
And I can, we'll go to the Register of Deeds and, present proof that it's free and clear. But I have a simple solution if you just made it 200,000, 2,010%, but I think the court's already indicated that.
No,
Simple
I'm way
solution.
past that, but thank you for this.
I'm always trying to help.
Yeah, I know. Okay. All right. So I need to get that in writing. That's going to give the prosecutor time to take a look, and
Sure.
then that's going to give the court time to do what I'm doing. I want to make it clear. I'm not saying yes or no to any of it. I just
understand.
want to see the entirety of the package.
Okay. I will try to get something to you by Monday, if not sooner.
Fair enough.
Fair
And
enough.
just so that you know, you need to get that to me, and then I'm supposedly on this thing called a vacation, but I'm not sure when that begins. I'm not even sure where vacation is. When does that start?
It starts, 1:30 on the 13th, no, it starts on the 14th.
14.
Oh, I hope we could get this.
No, right. I just want to make it clear so that if I disappear and don't answer.
Okay, I will try to get something to you no later than Monday. And
All right, mark your books, everyone. We're not going to have Simpson for at least a week. Going on vacation in the middle of August, which he deserves it. He deserves it. Also, thank you so much, Mayor, for the 5 gifts and memberships. I appreciate it, bud. I appreciate it. Thank you so much, and welcome to the 5 new members.
I have sort of a busy day tomorrow, but if I can put everything together, rather than preparing the quick claim deeds now, I'll put everything in the proposed order of how it would work, and then obviously we'll have to get the quick claim deeds prepared and so on.
Gotcha.
Okay?
Okay.
All right, and I'll also maybe call corporation counsel and see what they might require.
Fine.
I'll take that upon myself.
That's fine.
Fair enough?
That's fine. Yeah, you can do that. I mean, that's fine. I mean, whatever it is, I'm gonna be sending it there and just understanding that it's my final decision. But like I said, I want to make sure that everybody's covered.
Okay, and I'll also put in the other property that's worth $450,000 free and clear.
All right.
Can I have a moment with the client, Your Honor?
You may.
I was in a meeting yesterday and I got a notice that someone had COVID.
Sure. Thank you for talking out loud in this room then. No. You may want to, counsel, hit the mic, counsel, just hold on the button. You can lean over, but it's got to be flashing green. Otherwise, believe me, these mics, you got to hold it down. So you got to hold it with that hand. Take that, no, not that hand, the other hand. That hand, just put it on the button. No, come on. Put it on the button. And then use that hand. GSOP, and then you can lean over.
I get it.
Your other right hand. Your other right hand. Come on. Just press the button. Just press the button. Come on, just press the button. just press the button. Just look at Judge Simpson's face right now. He had the same conversation with him the last time.
Indulgent. Today's the day for the PCC.
It is.
I'd like to put that over one more week with the prosecutor's consent, and I haven't spoken to her about it, to see what we do with the bond, and then as we did the last one. So if the court is agreeable to that, I'll try to get everything, and then we can have a probable cause conference for next Thursday. If he's out, we'll go ahead with it. I mean, whether he's out or not out, we'll make a decision then.
Okay, so let me ask this. Where are we, since you had a lot to say, Ms. Blanche, where are we in terms of discovery and other things?
2 weeks, I was told that, from Tuesday.
Pardon?
2 weeks, my officer told me 2 weeks from Tuesday is when they're gonna get the toxicology back.
Got it.
If that's what you're asking.
Yes, well, I'm asking regarding that, and so. Okay,
Your Honor, she's provided with all the discovery. I think that pertains to this charge.
You got an evidence.com link too, right? You got all the video?
I don't have the video, I just have stills.
I think it would be an Evans.com link. I'm pretty sure whatever I have, I've shared with you, but I'll make sure.
Okay,
I'll make sure.
It helps when I unmute myself. I think he put the mask on to muffle what he was saying to the defendant because he couldn't figure out how to press the button. But he took it off real quick. He only had it on for a couple seconds. That's what I'm assuming.
I don't know that the videos are all that important anyway in this case. I don't know that there's any dispute over where the body was found and that sort of thing. So.
Okay. I just want to make sure that I understand we're having argument regarding the bond, and I get that. But I also want to make sure that the case itself is
It's
proceeding
moving, sure.
and heading forth. So,
Never been my idea to stall a case out when someone's locked up, I can tell you that.
okay. So you would like a hearing next week regarding all of this, regarding the bond and the like. Okay.
Right, and I'll try to have everything to you by Monday with the understanding that the court will look at the order, say, okay, Mr. Krieger, it's either fine or not fine, and then I'll prepare all the deeds and so on.
Okay, so here's my issue with your timing, is that if you get everything to me by Monday, and let's say you're talking with corporate counsel, you're talking with that and doing everything along those lines, and the court you'd be asking the court to make a decision basically on 2 days. And I don't know that that's a practical way to do it, just timing wise. I just don't. I think we'd get here next week and we'd be maybe further along on some line, but wouldn't have everything.
Well, you certainly wouldn't have the quitclaim deeds until you approve the order, then I would.
No, you're right. But what I'm saying is, I'm not sure that all of the information and everything's going to be here then. Now, here's what I don't mind setting it the 8th. My preference would be to set it on the 13th because I have a PCC prelim docket that day.
The 13th?
And I'm just thinking that would be timing wise, counsel. I'm just thinking if I were to make a decision that we could go along with this, that we could have everything digested, have everything in place and make sure that everything's tied up. That's my suggestion. I will set it for the 8th, but I'm just not hopeful. I mean, I hate to get here and then we're still here and then I push it to the 13th in any event.
Let me just make sure I understand the court. I can do the 13th in the afternoon without a problem. I got something in the morning in federal court, but so the idea would be to present the order, the proposed order for the bond. You would look it over and then on the 13th say yay or nay, and then I would have to prepare all the documents to facilitate that, like the quitclaim deeds and so on. Am I reading the court correctly?
Yes.
Okay.
That's what I'm looking at. That I just want to make sure we have enough time to say, yes, this is what we're going to do, if we're going to do it.
Okay. All right. And I will start working on all of that right away.
So, and
you would want all 3 properties now to be listed in there, including.
yes, because and it's not agreed at all on the court's part or anything along those lines. I don't agree. I agree with in some your analysis, but I don't agree in terms of the value in numbers, because I'm looking at it that if at some point I instructed somebody to get a mortgage on something, I'm not going to be able to mortgage it to the max of that appraisal. That's not going to happen. So I don't think the numbers are as high as you're saying that they are.
If you add in the 450,000, that's free and clear. Now you're up to, oh, I'm sorry. Okay, you're
Off of that one, I'm only going to get about 400, maybe 380 if I had to mortgage it. But I mean, we're just looking at it from different sides. I mean, we're still looking at the same thing.
my idea you wouldn't mortgage it, you would just sell it, right?
No, I understand that,
that the county would foreclose on and then get a realtor to sell the property at whatever value it can get.
Yeah.
With interest rates supposed to go down, maybe you'll get even more money. But I'm confident he will.
If I wanted to be in real estate, that's what I'd be doing.
But
That was not my intent.
But I'm confident Mr. Hajar will appear. I don't think there's any risk of that change.
Okay.
Okay, thank you.
Okay, so we'll adjourn probable cause conference and the bond hearing to, and you are here that day, 13th,
Yes, Your Honor, I'm here
for other things.
After you.
Yes, it will be, well, my probable causes are in the morning, but I'll set this in the afternoon. What time are you looking at?
2 p.m. Sure.
August 13th, 2024 at 2 p.m.
And I'll try to get. Do you know anyone in corporation counsel you could recommend?
I do, I know all of them.
Is there someone that would?
I don't know who would be doing this, so it's probably just to reach out to the listed corporate counsel because they may go outside on something like this, because it's not a very large office, but I don't know.
Thank you.
Yep.
I'm not gonna make any additional. Judge, I just wanted the court to be aware, Mr. Hajar is requesting, doctor, he is having some medical issues, I just wanted.
Right now, or,
No, yeah. I've been having high blood pressure and they check me 160 over 98 to 101 constantly, and I asked them to just do something about it. It was not feeling 100%.
but they've been checking you at the jail.
They check me, they tell me they're gonna send me to, they tell me it's a doctor, but nothing has been happening for last week.
Okay. So as I indicate to people, I am not a doctor. I have no medical training. I leave that to the jail and medical staff. I've never known this Washington County Sheriff's Office not to respond when you are saying, I have these symptoms. They will check them. There may be disagreement as to exactly what's going on, but I've never known them not to make the proper call.
You check it, but nothing happens. And they see the numbers are high.
Okay, and what do you want them to do?
Do you take high blood pressure?
I never took it, I just had a good diet.
So you're not on medication?
I never took medication before.
Okay, then that's gonna, I would imagine, require a whole other set of things. I would talk to medical at the jail. I'm telling you, they're very good. I mean, it's not as though they're not.
Thank you, Your Honor.
All right, thank you. Oh, you can have that.
All right. Yeah, I was itching for that hearing to be done. I've got 2 more from Judge Simpson, and then we're going to call it a night. I had a 4th from Judge Stevens, but you know, Lone Wolf decided to play it this morning, so I may wait to play that. Lone Wolf. Anyways, yeah, we're still in Judge Simpson's court, but we're gonna change directions a little bit. We're gonna watch him yell at a few people. So I feel like we need that after watching that case or that hearing. All right, let's go. Oh, one more thing. Powerhouse. I still have no idea who you are, but thank you so much for the Cash App this morning. I appreciate it. I wanted to shout you out at the beginning, but I was too focused on getting the stream up and running from being so late from my power going out. But Powerhouse, whoever you are, thank you so much for the Cash App.
Those Gates people versus Bobby Beach.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Beach, who should be present via Zoom. For the record, Your Honor, I'm surprised he's not here. I've talked to him.
Me too.
I have talked to him several times this week, including this morning when I sent him.
that
Oh,
him?
there he is. Mr. Beach, could you please unmute and state your name for the record?
Next time, change your name. State your name.
Phones it. Okay, Bobby. Bobby Beach.
All right.
Thank you, Your Honor. My client wishes to set this matter for preliminary exam. Discovery is complete to our knowledge.
People have their witnesses available on the 13th.
I don't know if I can have that done by the 13th.
Gotcha. He's out of custody, so preliminary examination in person without objection will be set August 20th, 2024, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor. You said August 20th?
Yes.
Thank you, Your Honor.
Thank you.
There's a bond violation. Well,
Is there?
because the report is dated July 31st. Missed test on the July.
Why'd you miss your test on July 22nd?
What date was June 18th? Because I could have believed I went up there and they said, this is Juneteenth, some type of Black history. They're not even testing the day.
Really? Really? Some kind of?
What do you mean, some kind of? I'm telling you what they told me at the
Some kind of
door.
Black history thing?
I'm out here in the street. I go test every week. I don't miss a beat, and I give y'all $50 a week to test for marijuana that I have a marijuana card for.
Mr. Beach?
Okay.
Mr. Beach?
All right, so I'm going to start again. On July 22nd, I'm now out of June.
No, he asked specifically what date is June 18th. I love the look on Judge's face when he said that. What date is June 18th? What is this Juneteenth thing? I mean, it's funny.
July 22nd, I have a report that you missed a test.
I have all my receipts. So I don't miss no tests. So a urine test, I don't miss no tests. I go to all my tests. I pay y'all the money. And y'all tested me for marijuana. And I have a card for marijuana. So the taxpayers is paying for me to be tested for marijuana.
Mr. Beach?
Okay, so we can have this in person. Why don't we deal with this in person? We can do it this afternoon. He available?
I do not know, Your Honor. I have not been able to.
Okay, 3 o'clock this afternoon. We'll set it for a bond hearing. Beautiful. Thank you.
All right, Mr. Beach.
Put that on my 3 o'clock. I'll see you then. Thank you.
Please give me a call.
Yeah, you might want to do that. Court calls the case. People versus Leon Odom.
Clearly.
All right, we're fast forwarding to this part 2 of his hearing today. Now, I wanted to keep in the hearing after that because Judge Simpson kept making jokes to the public defender, like, does your client think I'm wasting taxpayer money? But it would have been just a time filler, and didn't need it. All right, fast forward.
At what time? I just didn't know. I said she's got to go way up north. We're going to have a problem. Okay. Court calls case People versus Bobby Beach.
Andrew Chubb is appearing on behalf of the people.
Mr. Public Defender Natalie Pate with and on behalf of Mr. Beach, who stands to my right. Please state your name for the record, sir.
Bobby Beach.
Thank you, Your Honor. I have been able to have a discussion with my client.
All right, I just want to give a quick shout out to Mr. Beach. He got dressed. He was wearing a tank top on Zoom. He put a shirt and a tie on. I mean, and he came down to court. He, that has to mean something. He took responsibility, got dressed properly, and came to court. Now, him acting a fool, I can't excuse that, but at least he plays the part when he shows up to court.
In regards to his missed test on July 22nd.
I hope it was shorter than the one we had this morning.
It was longer, Your Honor. He does acknowledge that he does miss the test. He apologizes for both his missed test and the miscommunication this morning. He has been going through a lot. He did provide me with an obituary. His father did just pass on July 23rd of last month. We respectfully request that the court admonish him for his missed test and allow him to continue while on bond. I did note that when reviewing the report that it was labeled as a progress report. He does have a valid medical marijuana card, and that is what he has. His only positive tests have been for that, which he has provided the card to community corrections. We are respectfully requesting that he be able to continue out on bond.
Can I just ask, when we were on Zoom, why couldn't you just tell me that? My headphones were going out. I was trying to put them on Judge Simpson. Hang on. The only question I asked you was why you missed that test. That's all I asked you, and you went off into whatever.
I thought you said June. I was thinking about.
I know you went to June and then talked about the Black holiday, the thing you probably really should know about, given your heritage. But outside of all of that, I asked you about the last missed test, and you started to act a fool. That's all I can tell you.
I'm going through it. I apologize. I'm sorry. I really do. I'm sorry. I gotta go to this funeral tomorrow. My dad is 90 years old, gone. Worked at Ford plant for right there, gone. I just apologize.
Anything from the people? It's going to indicate no action taken on the missed test of July 22nd, 2024. This matter will then continue to the August 20th, 2004 date for preliminary examination before Judge Valvo. I suggest that you conduct yourself a whole heck of a lot better than you conducted yourself before me.
I apologize. We kept the same date you previously set.
The August 20th, yes.
Thank you, Your Honor.
All right, last one. We're still in Judge Simpson's court. Now we have a much younger defendant, but yeah, that last guy, he, that might be the negative consequences to medical marijuana. I don't know, but yeah, his headphones going out. Maybe, I don't know. All right, last case. Let's go.
Court does call the case of the people versus Marcus Moore Jones.
Andrew Childers, on behalf of the people.
Good afternoon.
You're still here.
I am. This is the last time the whole summer.
This is it?
Mm-hmm.
Oh, kind of sad. Anyway, go ahead.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Moore Jones.
Marcus Moore Jones. All right. What are we doing?
Your
All right, before we get into Mr. Moore Jones, can someone pause at the perfect time? Someone needs to answer me why the prosecution table is slanted. It's been bothering me. It's been this way for about a week. And I noticed it the last time when Judge Simpson said if that guy would have been in front of Blanche, he would have punched her, or she would have punched him. Yeah, he said Blanche would have punched the dude that came to the prosecutor table. Do you think they did that so it was harder for them to get to the prosecutor? I don't know, but it's bothering me. I don't like the crooked table. It's in my head.
Honor, we spoke with the prosecution this morning about a potential plea deal. We are asking for an adjournment in this matter to discuss the offer further and to give our client time to collect the restitution.
Okay. So part of the plea is restitution. So timing wise, how much time do you have a number, and then how much time is it going to take him to try to?
We do have a number. A few weeks, Your Honor.
A few weeks. It's your last time. You're gonna make this difficult for me, aren't you? How much, young man? You've seen the number that they have? Yeah. Okay. How much time is it gonna take you to try to come up with that?
Maybe 2 weeks, maybe.
About 2 weeks. You're gonna be able. Okay, I don't know what the number is, but that's fine. All right, let me do this.
Not that bad, but it's 700.
It's 700. It's gonna take you 2 weeks to come up with that?
I mean, I work, but I got priorities. I mean, I know this part of my priorities. But
Okay, no, stop talking because you're gonna get yourself in trouble. No, you saved that one.
No,
I
I
got
said 2 weeks. I'm not doing one payment. I don't want to do that. That's all.
You what now?
Big payment. I don't want to do that. I
Do-
can't do that.
Can't do what?
700 at once. That's what I was saying.
He'll have it in a couple weeks.
Right, that's all I'm trying to figure out is how long it's gonna take you to do that without messing your whole self up. I'm just trying to set a date that you can try to make it happen.
Yeah.
And you're saying a couple weeks that you think you can do that.
I work
Okay.
every day. So yeah, I said.
Well, I know, but I'm just saying, you also got bills.
I decided to not comment on bringing the baby to court. He was on Zoom. He came in later in the afternoon that he wasn't scheduled for. Not going to comment on that. Yes, people bring their children as shields. It could have just been he didn't, he had court in the morning and then he had to go to court in the afternoon, and it was, because of his inability to answer a simple question. But still, I wasn't going to comment on that. And Judge Simpson let it go. He didn't. He generally mentions every child or baby that's in his court, and he completely ignored it as well. So I think him and I were on the same page with why the baby was there.
Yeah, I mean, we're just trying to give you enough time so you can do it
When you
without.
asked me, I said 2 weeks though.
So let's do September 5th is great, Your Honor. Mhm.
You know what? I'll just make it next week and then you don't have it, right?
Yeah.
I mean, I'm just trying to give you time, young man.
It is what it is.
Oh, no, he ain't gonna say it is what it is to me. He can sit down and you can check him and then have him brought back up.
Thank you, Your Honor.
And you keep shaking your head and then I'll show you what I'll do. I refuse to be nice or understanding anymore today. No, ma'am, that includes your case too. All right? Court recalls the case, People versus Marcus.
All right, we're moving on to the second part of this case when he calls him back. Judge goes easy on him, but I mean, he didn't. The kid didn't really do anything wrong except for he didn't really understand what was going on. And I feel like he was trying to talk to the defense attorney and the judge at the same time, and there was just like a little bit of miscommunication. Then he was disrespectful when he said it is what it is. So yeah, I mean, he's a kid. That's a slang term, it's used. And so, anyways, I'm gonna let this play out, guys. You guys are awesome. I am so sorry for being late. My power stayed on. I went to cancel the live and my power came back on right when I was able to remember what my password to StreamYard was on my phone so I could log in and cancel it. Boom, came back on. So thank you so much for sticking around. I'm again so sorry I was late. Was out of my control though. My mods are awesome for holding down the fort. We are gonna raid Jen. She is showing an interview with Judge Boyd where she asked a bunch of creators to put videos together to ask her questions. We are really late though. She started 21 minutes ago. So hopefully we're gonna get the tail end of it. And yeah, but I'm gonna let this play out so we can get over there as fast as possible. Thank you so much, guys. You guys have a great rest of your evening. Until next time, bye.
More down.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Moore Jones.
Marcus Moore.
We're requesting a 1-month adjournment in this matter.
How much?
1 month.
That'd be enough time for you to get it all together and get. Young man, do you understand what I was trying to do? I was trying to make it easier on you.
I apologize. It was a misunderstanding.
Right. And I just say this. The problem is that you come in, I'm just trying to make it easy on you so you're not stretching it.
Right.
And your attitude almost got you into a whole lot of trouble that wouldn't have even been worth it. Understand me? So just listen to folks. Probable cause conference, September 5th, 2024. 9 a.m. or as your invite indicates, bond will continue. Is he paying, you don't need an order for him to be able to pay that to the court, do you? Or how were you guys gonna do that?
I believe Mr. Moore Jones had made a comment that he didn't want to just do it all in one lump sum.
Right.
So if he wishes to make payments, an order can be made so that that can happen. I don't have an issue with that. Right? If we submit an order to the court allowing payments to be made on the restitution.
Yes, if you submit an order that we then hold it for payment, we'd hold it as what technically a bond, but to be paid out for restitution. That way, as he gets paid through this period, or as he has the money, he can pay it here so that he doesn't have to come up with it all at once and try to hold it or do whatever.
Okay.
Okay. Okay, you want to do it that way? Okay. So when you come up, the only thing, so you guys have prepared the order, I'll sign off on that. The only thing you have to remember, Mr. Moore Jones, is when you come up to make a payment, because it's going into effectively our trust fund to hold, it needs to be paid in cash.
Okay.
Okay. Okay. All right. So that way, then when you come up, you can just, you got 200 here, whatever, you can just pay it.
I'm gonna do 3 next month, 300, take half of it.
300 when?
September that day, September 4th.
So
hold it. What are you guys trying to do? Are you trying to pay out the whole 700 or
September
just a
5th.
bigger or
I'm
just
at
a?
5th, that was 5th.
on September 5th, my client can pay the $700 in restitution
Whoa.
or $675.
Right, whatever the amount is. I'm just trying to make it easier on him so that, because he said he didn't want to come up with it all at once.
Yes, and we were discussing a 2-week. We went back, we talked about it. We think September 5th.
No, and that's fine with me. I'm just saying and maybe I misunderstood. Was he trying to pay it all at one time? Like he just needed more time, but he was going to pay it all at one time? Or was he?
Yeah, I'll be in Discord. I'm gonna go check out Jen's stream after this, but I'll be in Discord after that. Yeah, that's all I got.
Gonna try to pay it like he'll get his paycheck and then he was like, well, let me do this so I don't spend it.
Right.
Is that what he wanted to do? I just don't know.
See, when we went back, we were speaking on just paying that 700.
Just in one lump.
When I came up, he had said the payments. That's why I said I can pay 3 that September 5th. That's what I was meaning to say, but.
So.
Okay, let's do this. Let's do the order.
Okay.
Okay, and then as he has it, he can come put it, if he has it before then, he can come put it in there so that it's just there. All right.
Can I just come to that office? Okay.
Come to the window up front, make sure that you have something with your case number on it. So that they'll give that to you. So that then they'll see it in the file once we get that order in place and then you can just pay on it. All right?
Sounds good.
Thank you.
All right.
Thank you.
Hey. And next time, just check the attitude, man.
All right.
Okay? Because he hasn't done much today and he almost had to take you. All right, take care.